Good morning. I am Payal Manhas. I am from Landmark Group, Dubai. I take care of the digital and e-commerce portfolio of the group. And today we are discussing about a very burning topic, which is of immense importance, immense discussion, is it's something which is very real now in front of us, and companies ranging from retail, banking, uh, you could have e-commerce, everybody, each of the consumer related company is now facing the issue of data protection. And I would not like to go to the specifics, as we are aware what data protection is applicable on. It is about the personal identifiable data of an individual. For a retail group from which I come, we are having a very large exposure to customer data. And as you may be aware, there are retailers in the malls. Landmark Group has diverse products. For example, you could go to a home center where you have home furnishings, furniture, to a fashion retail like a Center Point Lifestyle, to electronics like a Emax, and also to a marketplace, which is an e-commerce platform. Like, you have all the e-commerce giant players, and you have retailers, sellers selling on the e-commerce. What is common between all of these is there is immense customer data. For an example, our one store could have data for more than 20 million users, 20 million customers. So that is the kind of data that a company as a controller has to look after. And this is what, as a controller, what are the obligations of a corporation, of a company, to protect the data of their customers who are coming and buying from you the various product range that you're offering. As a council, uh, when you are looking at these issues in the business, the first thing that comes to you is, how are we contractually secure? How are we safeguarding the contracts from the perspective of data protection? The contracts in the companies, are generally tech contracts. The technology is, if you have e-commerce, and as you would know, Landmark does have e-commerce. It's an omni-channel. All of its stores are also available on the websites, on the apps. The customers can go there and purchase all the products. They could have it delivered on the couriers. You could come and click and collect from the stores. So all of this is a tech, is a technology behind all of this. And as a controller, to all our service providers, to vendors, there has to be contracts. And the data protection provisions are what is now newly being added in all of these contracts. The contracts need to have clearly stating the data protection obligations of the controller as well as of the processors. It could also define the obligations of cross-border transfer of the data. As you would know that most of the service providers have their data centers outside the jurisdiction. Especially if we are sitting in the Middle East, we could have a contract with a service provider who has data centers in the EU or in the US or in the other Asian markets. So this is a primary uh, responsibility of a controller to have contracts which define data protection obligations. The second aspect is vis-a-vis the customers. We need express consent as per the the laws, and that goes for laws in the Middle East and also the GDPR. The express consent is how the company gets it, how they are going to process it. And a company like Landmark generally gets the consent on the customers through its POS or through its website or through its app. And each of the consents need to be registered with the company in order to process it. So this is what is, a perspective of a retailer, of a consumer related industry. And I would like to ask my fellow panelists who are from the technology area, specializing in the tech, and how as a processor they see all these challenges and how they are coming up to face all these obligations. So, Mr. Wayne, would you like to add on this?
Hello, everyone. It's a pleasure once again to see all your faces and to be here again. It's amazing for me. I'm extremely excited to be here. And on my right, Payal is actually from Landmark Group, which is one of SAP's customers, one of our great cloud customers. So what we've seen in the technology space is a tremendous shift in customers adapting from an on-premise environment where they store their own data in-house in their own data center facilities to a cloud environment. And that's happened in the last 10 years since I've been working in my role. There's been a huge shift in customers moving to a cloud environment. And to accommodate the needs of government to store and provision their data locally where they are located, companies like us have been trying to do our level best to have local data centers around the world which can accommodate the needs of various parties. So I speak here about the government. Government has, of course, national interest to protect their citizens and their residents, and they want to avoid unnecessary foreign influence or access to their data. So therefore, there's been a huge shift from cloud services providers to set up local data centers in country, in the regions around the world, including the UAE. Challenges that's brought is immense. Setting up a data center is a huge investment for any company. It requires a lot of high capacity hardware. It requires a secure, physically safe environment with which the data is hosted. And within that building, you have separate cages, a little bit like a locker room for the cricket club, where you have your lockers, and instead of the cricket bats, you have layers and layers of high capacity data center servers, which are connected, of course, to various backup utility sites, disaster recovery sites, and also your headquarters or networks which you're leveraging to deliver a cloud service. So I think when I talk to our fellow customers, one of the things that our team needs to really explain so we're all on the same page, is the architecture of the cloud service, where the data is being provisioned, where it's being transferred. And it's a really tricky challenge for cloud companies, because in the current world, you've got government trying to restrict the flow of data from cross-border transfers. And on the other hand, in order to provide the cloud service, there is a necessity to transfer certain data outside of the country. And that's for various reasons. For support, you have global support centers around the world. For example, Argentina. You've got someone sitting in Buenos Aires who's receiving technical queries and support tickets from Landmark Group. So they, by very nature, need to be able to access the data if the IT person in Landmark Group is sending support tickets with particular data extracts that need to be checked. Yeah. There's also the aspect of monitoring data. So cloud companies need to be able to monitor operational data, metadata, for various reasons, for checking the capacity of the data center to run the service, for security audit logs, to check user profiles, to avoid hacking as part of the cybersecurity activities. And all of these cloud services require a massive amount of data to be flowing from country to country in order to provide the cloud services. Of course, most of that data should be anonymized, but it's not completely anonymized. There are certain data like IP addresses, like user profiles, the details of the person logging a support ticket, for example, their telephone number or email address, which does need to be transferred. So this creates a dilemma for cloud companies in being transparent how the cloud services are running, and also working together closely with government to make sure they understand these realities when they implement new laws and regulations like we've seen in this region. So the UAE is a good example. They've implemented the federal data protection laws last year, and we're waiting on the new federal executive regulations to come out very soon, which will give us a lot of direction in terms of what we can and cannot do to provide cloud services to our customers and protect their data.
Yes, I guess there are a lot of open issues that will get resolved in the next 1 or 2 years. And primarily, we are facing this question: what is data transfer? How is it going to be dealt with? Because data transfer is now a very restricted activity as per the Middle East laws and the new legislation that has come up. Even in the KSA, there is a provision of specific approval required if you have to transfer data out of the country. And that is where companies and the service providers both need to see how are they going to manage that. You know, are they going to take the approvals from the government, or are they going to shift their data centers to the Middle East, or to KSA? This is one of the questions that is going to be answered soon, and we don't have answers to that as of now. And Raghavan, you're virtually with us. We would like you to share your experience in the field regarding the digitalization and the new laws coming up, and the kind of jurisdictions that you would like to touch upon.
So thank you very much, Payal, and my apology. Can I can be heard? Can I be heard?
Yes, you can be heard. Thanks.
So thanks, Payal, and my sincere apology to the panelists and everybody that I was not able to attend physically because I had to travel to South Africa for certain urgent work. So very interesting discussion. And like you said, the Middle East has just passed that data security law, and we are still waiting for the executive regulation. So I just give me my background. I am the group uh, legal head compliances and the risk of the ISON group, and our group is into the IT sector, customer services, and we are across Africa, almost 36 country, and Middle East. And like Payal, you said that you have the customer data, so many customer data as a controller. So we are having the data of around 50 million customer across 36 jurisdictions. And mostly we are as a processor, not as a controller, so as a service provider. But at the same time, we have to ensure that the law of the each country and as well law of the each country as far as the data protection is required. And the last year into 2021, we have seen a lot of change in the legal landscape across globe as far as that data security is concerned. So uh, basically, if you see that last year China has implemented data security law, UAE we already discussed, Brazil, Russia, Switzerland, they all are coming with this new regulation, uh, and they are trying to cope up with the change in the technology. That's the technology is bringing a lot of a complex situation for the regulator, because it's a cloud, like Mr. Van said, that cloud issue, AI issue is there, and various things are there. So law is still catching up with this new technology advancement. And the situation as far as the data transfer of the cross-border data transfer is concerned, after same two ruling of the, and so for my experience, we are onshore business also service provider and offshore service provider also, and many of our client is from the European Union. And after the stream 2 ruling, that the cross-border transfer is getting difficult these days. There is a lot of regulation by the EDPB coming with, as far as the adequacy decision is concerned. But at the same time, this is the very welcoming decision by the EDPB, that they have come up with the guidelines about the legitimate interest, blockchain, calculation of the administrative fine, and on the same basis, that the different country like Australia has ruled that the provider of a website using Google Analytics was illegally transferring data to the US. In Italy also, we have seen that the Milanese University has been fined around euro $200,000, sorry, pound 200,000. Germany also considering the transfer of data without having the proper risk assessment is unlawful. So these are very difficult situation we are as far as the cross-border transaction is concerned. But at the same time, the European Union is taking lead in everything, and they came up with the new set of the standard contract clause that is going to be so already issued from the 27th September 2021, and all the existing contractual arrangements should adopt this new set of contractual clauses by 27th of December 2022, if I am not wrong. And e-privacy regulation is also being finalized, that is going to replace the 20-year-old e-privacy directive. So this is from the data protection side, and why this the situation has arisen to protect the data because of the cyber crime. So when we talk about the data protection, we must talk about the cyber crime also. And from that aspect also, even European Union has taken lead, and they have revised the Network Sector Security Directive, that NIS directive, and they have expanding the scope and seeking to harmonize further this sector across all level, including tax. So this is from the UAE perspective. China, I already mentioned about that where we are dealing with the client. India is still law has not come up. Law bill is pending with the parliament. I want to touch upon the Africa, because Africa, we have the most business in Africa. So, so new development in Africa is very welcoming. Like Botswana had come up with the Data Protection Act last year. Nigeria is trying, but it's not law itself, but they come up with some regulation like Nigeria Data Protection Regulation 2019 that take care of the data protection there. Rwanda came up with the last year. So last year was a very exciting year as far as the data protection is concerned. South Africa also last year they have implemented after 12 months of the transitional period. So it came first from the 1st of July. It is effective now. one thing I want to like to mention again, that the most of the law that is being framed for the data protection, they are taking the guidance and from the GDPR. So for the data protection point of view, knowing and understanding GDPR is very important. Uh, so, so that's it. That's it.
You're right, Raghavan. The challenges that we are seeing in the new era and the new landscape are definitely what we all need to really work on. And we need to have some kind of a program or a protection regime, you know that that the companies, that the countries need to follow. So Solomon, would you like to tell us about the sustainable digital identity program and a successful reliable data protection regime in the jurisdiction of Africa?
Yeah, thank you, Payal. First of all, I must say that in my experience working as a uh, private practitioner, and of course as a legal researcher with Columbia University Global Freedom of Expression Project, I've realized that state actors are actually the biggest violators of privacy all around the world. And of course, they easily do that under the guise of national security. And we all know that national security is not just a defense you can invoke, in vacuum. There must be some element of particularity to issue of national security. Now, one of the things that happened recently in 2021, the development partners to Nigerian government, which are World Bank, European Investment Bank, and FAD, got my friend to work on a consultancy project for them in order to allow Nigeria access some fund to run its digital identity program. Now, while we were working on the project, one of the things we discovered was that even the duty bearers, now I'm talking about state actors, actually do not know that they have very uh, deep responsibilities to the right holders. Now, when we're talking about deep responsibilities, you have people go to the enrollment centers now for enrollment in the national identity scheme, and some of them don't even know why they're there. Now, because there should be a clearly stipulated reason that, look, before you are captured, you must know why your details have been captured. Now, there's something called purpose specification, in the whole principle of data protection. Now, and if for whatever reason, now you are a vulnerable person or you are a physically disadvantaged person, what are the heads the data controller is actually putting in place? So the very first thing we need to look at is that there must be a comprehensive data protection legislation. Now, in most parts across the global south and in Africa specifically, most nations do not have comprehensive data protection legislation, which I tell you, the state actors explore to violate people's personal data. Now, I'm going to give you a very clear example of Nigeria. Now, sometimes you during the election, maybe general election, you sit in the comfort of your room and you begin to receive um, adverts, campaigns for election or for a particular party or a particular candidate. And you wonder how they were able to access your personal data, your phone number. As a matter of fact, the message will come so direct that you will know the sender knows your personal detail. Now, but the issue is this: your personal details oftentimes are being actually are being accessed by state actors through the back door. Now, the question is, should that have happened? Yes, it shouldn't have happened. But the reality we have is that we do not have a comprehensive data protection legislation in place. Now, another thing I'm going to talk about is we do not have effective enforcement mechanism. Now, I need to state this clearly. Now, when for whatever reason a data subject alleges violation of their privacy or personal data, where do they turn to? The courts. Now, I realize over time that some of the judges, particularly in Africa, are not even aware of the whole concept of personal data. And if these judges are not knowledgeable in this area, then the issues of violation of personal data will be a regular occurrence. Now, so when you look at it, so we need to have an effective enforcement mechanism. But for us to have an effective enforcement mechanism, we need to be sure that the judges who are arbiters of the dispute around allegation of violation of personal data on digital identity actually know what the dispute is all about, actually know what is the concept of personal data and what amounts to violation. Now, so that has been a regular experience. Now, I could recall a particular instance, and I was addressing a court in the case of violation of personal data, and the judge was puzzled as what data it's all about. But then you see, you can't blame them. They don't know. And what you do not have, you cannot give. That's the position of the law. So, for us to have a sustainable digital identity program, we need to be sure that we have knowledgeable judges who are going to look into disputes arising from such matters. Then we need to have so effective enforcement mechanism. Now, but beyond all of that, one thing that regularly comes to my mind, which I love to share, and that is actually picking from the position of Wayne. Now, when we are talking about the issue of national security, I can tell you categorically that now corporations need to see their responsibility as data controllers to their subscribers, particularly talking about the tech companies now, going beyond ethical responsibility to the issue of legal responsibility. What do I mean? Now, I'm going to cite an example of a case. There's this case, AG New York and Facebook. In that particular case, the state government of New York approached Facebook to access personal data of 185 subscribers in New York. And when they did that with one search warrant, one. And when Facebook received that, the first thing is that Facebook said, look, we are a global landlord to all our subscribers all around the world. And we have a responsibility to them, going beyond ethical responsibility, but a legal one. And the question is that if you were going to search the Facebook account, or you're going to search 185 buildings in the physical space, you cannot do that with one search warrant. We need to know why A's account has to be searched, why B's account has to be searched. In doing that, there must be element of particularity to each of the accounts you need to search. So doing that, then Facebook declined. They went to court. At the end of the case, the court ruled, in favor of Facebook, that for every search warrant that has to do with privacy of individuals, particularity is very important. And now, so what am I talking about here? I'm talking about the fact that corporations who are data controllers now to their subscribers who are data subjects need to see their responsibility to their subscribers as one that extends beyond the concept of ethical responsibility to a legal compliance.
Yeah, that's right. Thanks, Solomon. So from this, I think we also need to consider what the government and the role of the government in managing the data protection for the corporations. And do they have overriding powers to have access to the data in spite of the data protection obligations? So these are the questions that are relevant when the data is going cross-border. And if your data is going in the US, in the UK, you would have a situation where the government would have overriding powers. Also, when we are talking about the jurisdictions outside of Middle East, we contractually get into and undertake the obligations under a specific agreement called as a data protection agreement. In short, it's called a DPA. With the upcoming laws in the Middle East, and also with the existing laws in the UK and the EU, it is a question which jurisdiction DPA is going to prevail, and I think you would like to throw some light on how technology providers would now enforce or get into data protection agreements with their clients in the Middle East or maybe outside Middle East.
Yeah, sure. So I think it's fair to say that if we're talking about running a cloud service, it's quite expensive. It's a massive investment for any international company to operate. And therefore, there is a need to provide a sustainable service which can be delivered to our customers in the long term. That also means that there is a need to provide standardization and harmonization of the services to a high level. Otherwise, large companies providing cloud services globally around the world will not have capacity to tailor particular cloud services for each and every customer around the globe where they serve. And that also goes for government laws and regulations as well. To a large extent, the governments around the world are pegging their laws upon the GDPR, and many companies like ourselves at SAP, we also peg our DPA terms and conditions upon the GDPR. And that means that, for example, with respect to cross-border international transfers outside the EU, we have certain standard contract clauses which are embedded within our data protection agreement and therefore into our cloud agreement with our customers, which regulates our obligations or states our obligations towards our customers with respect to all the safeguards and measures that we are taking to protect the customer's personal data. So it's really difficult for us to change that. So if I take an example, if we're negotiating a cloud agreement with Landmark Group, as we have done before, it's difficult for us to negotiate a bespoke agreement based on the customer's own template, because that may not be aligned with our own internal processes. You know, we have our own global cloud operations teams, security teams, application teams for the various services, and it's all got to be lined up, and the agreement reflects our processes. So if we are going to change our agreement for one customer, we've got to change it across the board for all our customers in large. And that's something that we are doing, but we have to consider the broader global customer base when we make those changes.
So any questions from the audience? We're happy to answer. Yeah, please.
Do any of these jurisdictions envisage a click wrap kind of agreement for data? I know, collection of data has to be purposeful, but what if I were to simply allow for a click accept for data when I'm receiving data? And would that solve most of these problems? Because I did hear in the morning that advocacy in relation to personal data is something that you're trying to do. So would that solve the problem?
Yeah, you're right there. So there is a concept called as a consent management, which is not just part of data protection, but also part of ancillary laws like telecom. And we could take an example of a marketing message and a marketing promotional offer going to the customer. How do we take the consent? And that is where a click wrap would help. A click wrap could be on a website. So if you are going to a website of perhaps Centerpoint, purchasing some fashion products, when you log in, that is where you have a click wrap, a tick box, wherein you agree to the terms and conditions of the website. There would be an opt-in where you consent to get all the marketing SMS, and you consent that your personal data, whatever you enter in the website, can be processed by the company themselves as a controller and by its processors in terms of their software providers, developers. So that is where, when they click on the tick box, that is where the click wrap happens, and we get the consent, express consent. So this is how you're bang on point. This is how the companies can enforce and show that they have express consent from the data subjects.
May I add
And
something
the
here?
challenge is basically where all can we implement click and wrap, because not every place other than the e-commerce is it's not possible to have click and wrap. We were having physical consent papers, forms, which is now, looking back, is not feasible. So there are a lot of things you would find. uh, in physical stores you would have QR codes, which are also one of the forms of getting consent. You just have your phone, have a QR code, and then you get redirected to the website, and there where you can have a click and wrap, also a consent from your customer, you know, for whatever services or product you're providing.
So
Thanks.
may I add something here?
Yeah, sure, Raghavan.
Yeah. So just adding to the Payal what you said. So this tick box should not be that pre-ticked box, that the customer should have option to opt out or tick. That is very, very important. So the express consent is very, very important. And for the express consent, the customer should have option, either he want to tick that box or he want to opt out. So that's the major area of that tick wrap point of view.
Fine. I have a question from Mr. Wayne. You said that so far as the individuals are concerned, so far as the corporations are concerned, uh, any change with the individual contract the individual may have would have a global perspective and impact. Therefore, any agreement in the global context vis-a-vis the individual agreement, if I were to take it correctly, if I were to understand it correctly, that doesn't mean that there is no possibility of any data protection from the consumer point of view, or is it always conditional upon the companies holding the consumer data?
I'm not sure if I understood the question correctly, but maybe we can just have a further dialogue here. So there is the element of having standardized agreements and following a process in line with the global company processes, right? So, for example, if the customer or the data controller says we want to change the obligation for breaches for notifications in the case there's a breach of the data processing agreement. They want to change the notification timeline to say 24 hours or even less. That may be something that from a legal perspective, yes, we can agree on that, no problem. But practically, it will not be possible because the global operations teams are not working according to that timeline. So they would not be capable of meeting that timeline. So it's not to say that we can't agree on changes, and they are various changes that are justified and need to be changed, but it all needs to be assessed case by case with the relevant teams who are supporting the service, yeah?
Yeah, true, I think.
Would you like to just add something more to that, or is that?
Yeah, I get it. So it will be a very difficult from the point of view of an individual's agreement or a separate agreement to that effect in the global context. Obviously, the corporations are not going to concede that easily to have that kind of what do you call, privacy data protections agreements. Ultimately, it boils down to that.
See, can I answer that?
Sorry,
You have not got it?
Hello.
the sound's not very clear. I can't hear it.
So ultimately, it boils down to that there is no absolute protection in the hands of the consumers, in the hands of the corporations, insofar as the data they share concerned.
Well, look, I think in this day and age, the protection of personal data and companies' data is paramount. So as corporate citizens, we all play a role to protect their data to the highest level. And that may involve challenging government requests to access the data. And it may also, involve various steps taken internally also to make sure that any consent which is granted is free consent. There are loads of examples. In India, for example, you have a huge pool of IT talent, the biggest in the world, and they provide amazing global support to the world, to many tech companies globally. And in order to remotely access clients' servers, often they are requested to share with those clients or governments very personal information. And if it goes too far, I think we all have a duty to say no, even if the data subject is okay to share details around their family, their religion, their medical history, their political inclination, whatever. This is all highly protected, sensitive information under the GDPR. And in countries like India and here and globally, governments and also corporations recognise that we should not be asking for that sort of information to be shared to protect the integrity of their data subjects. So I think there's a...
May I add on to this? I believe the question, what I understood was that we are talking about the entire discussion was on whether there is a privity of contract. What if there is no privity of contract? Like Payal ma'am said that the millions of users go to stores, and I also go to one store, then I go to the second store also. So what if there is no privity of contract? Is the data protection still available to me in that case? That I believe was the question from the consumer point of view, right, sir?
So can I take this question? I understand the question. Should I take this question? Hello.
Yeah, I think we've got one more question.
Can you hear me?
I think.
Hello. Can I be heard?
Yes, Mr. Verma, go ahead.
Yeah. So I wanted to take the previous question. That what this gentleman wanted to understand that if there is a scope of change the contract, that a standard contract, this big tech companies like Microsoft and SAP and any companies forcing upon the consumer that they have to sign. So if that was the question, so basically there is a standard set by each jurisdiction. Like if the company corporation is coming into the GDPR set a minimum set of contractual clause must be in the agreement. So that agreement cannot be changed. Other than that, if there is another clause that mutually can be negotiated, and the change depend on that the power of negotiation, who has the power of negotiation. So that's one point. The second question was that like you go to any store and you are signing that that the form are you giving your consent. So I don't think that there is a choice there. But again that different law has properly secure that the consumer by putting the penalty and the enforcement clause in the GDPR uh, very strict penalty are there, and all other legislation also. So consumer can force their right even if they sign that agreement, because Microsoft is not going to change, SAP is not going to change that clause. But if they see that there is a violation, then the enforcement clause of that law has given enough power to the consumer to enforce their right. And there is plenty of cases, and the millions of dollars has been awarded to the consumers.
Yeah, I like to add to this. So one is we get into a privity of contract to answer your question. The other is that if there is no contract, there is still personal information with the company. They are going to protect it. The contract is for using it. They will not be using it, but they will definitely be protected.